Great. Well, thank you so much for joining us today for this webinar on damages claims in housing, where we have two illustrious speakers. So we've got Sarah Steinhardt and Nabi here to present. I'm Alice Irving. I'm joining the Housing and Social Welfare team at Doughty Street in September. Very much looking forward to that. Currently my practice is mostly in the area of disability discrimination. For those of you who are new to Zoom and haven't attended a webinar before, you'll notice that your mics are muted and that your videos are off. And this is just a presetting to avoid interference and so that we don't eat up the bandwidth and hopefully everything goes smoothly throughout the webinar. If you'd like to ask questions, you'll see at the bottom of your screen, if you hover, that there's a Q&A function. We ask that you use this instead of the raise hand function, and you'll be able to type questions in there. The panelists will try and deal with as many of those questions as possible at the end of the session. But if it's not possible for us to get through everything, then feel free to email the speakers or their clerks after the webinar, and details will be provided. Please also do note that we are recording the session, and a copy of this and the very helpful slides, which have some really excellent content on there, will be available for you and your colleagues who were unable to attend afterwards. So without further ado, I'd like to hand over to Sarah, who's going to kick off looking at damages in the context of tenancy. Thanks, Sarah.
Thank you, Alice. So I'm going to speak about the tenancy related claims, and then Zia is going to speak about claims that might be brought by a homeless applicant or somebody in homeless accommodation. So, of course, you could bring a damages claim under the Equality Act as a freestanding claim, or you could bring it as a counterclaim, and I'm going to be dealing with both. And of course, there's no real material difference. For many of you, this is going to be old hat. You're going to know quite a lot about Equality Act issues and discrimination already. But I'm going to start by doing a very quick, I hope, run through of what the basic principles are. And I'll try and deal more at the end with damages, how they're assessed, how the court approaches them, and what it means and how we do bring a claim for damages under the Equality Act. So there are three key concepts under the Equality Act. So we've got the concept of protected characteristics, which I'm sure most of you know about, and we'll come on to that in a minute. We've got the concept of regulated spheres of activity. So the Equality Act doesn't regulate relations between private individuals. It only regulates in particular areas. So under premises, in relation to education, in relation to employment, and so on. And thirdly, the Equality Act covers different sorts of prohibited conduct or prohibited activity. Discrimination being the most obvious ones, but also harassment and victimisation. You will also be aware, of course, that there are public law obligations under the Equality Act, but those do not give rise to a right to damages. So for my purposes, I'm talking about claims under Section 35. So Section 35 looks at discrimination in rented accommodation. Essentially, a landlord may not discriminate against an occupier, harass an occupier, or victimise an occupier. So just if I can flag up now that, of course, what that doesn't cover is people who may be a tenant but not an occupier of the premises, and that will cover, for example, cases of non-occupation. The protected characteristics. Again, most of these I'm sure you will be well aware of. So age means age group rather than your particular age. Disability we'll come on to in a moment. Gender reassignment covers people who are proposing to undergo or are undergoing or have undergone a process or part of a process for reassigning a person's sex by changing physiological or other attributes of sex. So it doesn't cover people who are sort of more broadly transgendered. It's specifically referring to gender reassignment. Marriage and civil partnership, pregnancy and maternity, of course. Race, we'll come on to in a moment. Religion or belief. Religion means any religion. and it includes being an atheist or not having a religion. And belief includes any religious or philosophical belief, and there's a case called Granger which looks at what attributes a belief has to have in order for it to attract the protection of the Equality Act. So disability, again, most of you I think will be quite familiar with this test. A person has a disability if they have a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on ability to carry out normal day-to-day activities. Most of that I think you will be quite familiar with. But I do want to just flag up one or two things. First of all, the impairment does not need to be diagnosed or a clinically recognised disorder. It's a word which is in ordinary use and which should be given its natural meaning. It is perfectly legitimate, in the case of J and DLA, Piper confirms this, to look at what the effects are of an impairment and to work back from that and assume that there must therefore be an impairment which is causing activities to be impaired. And that's a completely legitimate approach. And perhaps a good example of why we don't need to have a particularly medical or clinical approach to this is something like obesity, for example. If a person can't walk for very long, can't climb stairs easily, if a person is short of breath, if a person is unable to use furniture, those are all substantial adverse effects on day-to-day activities. And it isn't necessary to look particularly at what exactly is causing those impairments. The fact that those activities are impaired is ordinarily going to be enough. The third point that I wanted to make is that the assessment of disability focuses on what the person cannot do or what they can only do with difficulty. Now, in some ways, this goes against the sort of the social model of disability, which would tend to have a different focus. But those of us that do homelessness will be very familiar with decisions saying that because a person can attend their solicitor's office, for example, and give instructions, therefore they can't possibly be disabled. Well, that's a completely incorrect approach. Finally, the effects of medication or treatment must be disregarded. Race, section 9. There's a little bit to say about this, though again, I don't want to dwell on it too much, but the important point here is that when we talk about race, we're talking about a particular racial group. And that means that one cannot be discriminated against because they are BAME, for example, or because they are a migrant, because that is not a racial group. Those don't identify people who share a particular racial group. And this is very important when one comes to look at comparisons, particularly in relation to direct discrimination, because we compare the person who belongs to a particular racial group with everybody that doesn't share that racial group. And so, for example, if you think that you have been treated less favourably because you are Black African, for example, then the question is, well, less favourably than whom? The answer is everyone who is not Black African. And so you perhaps don't want to be compared with, for example, people who are Roma, people who are South Asians. That might not be a comparison which is particularly helpful. So, as I say, race has to be distinguished from immigration status, and a migrant is not, for example, a racial group. But there is a way around this problem, and that is that it may be that it is possible to define racial groups in the negative. So rather than to say that the distinction is between, for example, Black African people and everybody else, the distinction might be between people who are non-white and white. And that might be a comparison which is more favourable and more helpful. And I should say those three cases that I put up on the screen there are all pre-Equality Act cases, and arguably a slightly different test applies. But nonetheless, it's an interesting way of approaching that particular problem. So section 13, direct discrimination. A person discriminates against another person because of a protected characteristic. If it discriminates against another person, if because of a protected characteristic, A treats B less favourably than they would treat others. So again, that means setting up the comparison that I referred to earlier. Now that is not as straightforward as it might appear. Obviously there are cases when it is very straightforward, but there are also numerous cases where there is considerable uncertainty about whether something is direct discrimination or another sort of discrimination. And it's really important because in direct discrimination there is no defence of justification or proportionality or anything like that. If direct discrimination is made out, that is unlawful and that is the end of the story. So to give you an example of a case where it might be a bit more complicated, for example, if somebody is treated badly because they are a wheelchair user, for example, is that direct discrimination because of disability, or are they being treated unfavourably because of something, i.e. the wheelchair, arising in consequence of that disability? So in those cases, normally what I would do is to plead it both ways effectively and to cover both bases. As a rough rule of thumb, I would say that particularly in disability cases, what we're looking at for direct discrimination are cases where assumptions are made, where it's not actually about some true facet of that person's disability, but where a person has made assumptions. So for example, there is a tenant with learning disabilities and the landlord is doing a consultation to see whether or not some additional facilities should be installed. And the landlord thinks, well, this person isn't going to understand and they're not going to want to participate anyway, so I won't bother inviting them to participate in the consultation. I won't invite them to the meeting and I won't put them on the mailing list. That's the sort of thing that might be direct discrimination. Discrimination arising from disability is probably what we are all in housing most familiar with. And that is where a person treats B unfavourably, so no comparison needed, because of something arising in consequence of B's disability. And A cannot show that the treatment is a proportionate means of achieving a legitimate aim. And of course, there is the requirement of knowledge under section 15. So there is a defence for the landlord to show that the treatment is proportionate. Now there are two aspects to causation when we're looking at discrimination arising from disability. The first is, did the something arise in consequence of the disability? So for example, did the tenant's depression cause the rent arrears? That's the first aspect to causation. And then the second is, did the something, e.g. the rent arrears, cause the unfavourable treatment, let's say the possession proceedings or the notice seeking possession? So there are two aspects of it. Now, of course, in housing, most of the time, there's not going to be any dispute over why the person is being treated unfavourably, because most of the time, certainly in possession proceedings, that will be the reason why possession is sought. But there are lots of cases when it will be less obvious. For example, where there is a dishonest reason for why possession is being sought, or a dishonest reason as to why somebody's been treated unfavourably in another way. Knowledge, I don't want to dwell on this too much, but something that I think a lot of people are perhaps not aware of is when we talk about knowledge, what we're talking about is knowledge of all the facts which constitute a disability. So first of all, it's not about whether or not a person does or does not have a disability. A housing officer might, for example, have looked at a person's health needs and impairments and have concluded for him or herself, well, I don't think this person has a disability. And perhaps they even referred the case to an OT or to somebody like Now Medical, and Now Medical said, well, this person doesn't have a disability. that doesn't matter at all. Their opinion about whether it did or did not amount to a disability is completely irrelevant. That's something for the court to decide. What matters is, did the decision maker have all the facts which constitute a disability? We are quite used, I would say, to looking at knowledge of, for example, mental health difficulties, and thinking, well, because that the decision maker knows that that person has mental health problems, therefore they must be on constructive notice that that person has a disability. That is not necessarily the case, because we are looking at other features, for example, impact on day-to-day activities. That might not be known. Whether or not the condition is long-term, again, that might not be something which is known. That's not to say that there is, of course, there's a duty to make inquiries, there's a duty on a public body at least, to make inquiries and to satisfy itself. But nonetheless, it's important, I think, to bear that in mind, that we're looking at something more than being on notice that there may be an issue. Justification, as I said earlier, a landlord can justify their behaviour on the basis that it is essentially no more than is necessary to accomplish the objective. This is an objective test, so it isn't about what a landlord did or did not take into account, or did or did not consider, and a tenant is perfectly entitled to wait till the very last moment and say, well, actually, you could have done this. And in those circumstances, well, as long as there is an alternative, then it's likely that the unfavourable treatment won't be something which is proportionate. Indirect discrimination, I'll leave you to read that, because it's quite lengthy, and we'll come to it more in a moment in terms of what provisions, criteria and practices are. But what I would say at this point, firstly, this generally arises in the case of policy challenges as opposed to individual decisions. That's not to say it never applies in the case of individual decisions, but usually it's where those two things impact on one another. So, for example, L&Q had a policy, I think it may have been an unofficial policy some time ago, whereby tenancies that were on the intermediate market rent scheme, they wouldn't accept universal credit housing payments, and they wouldn't accept housing benefits. Well, women are overwhelmingly more likely to be recipients of universal credit housing payments or housing benefit, and so that policy is one which directly impacts on women and therefore indirectly discriminates against them. Failure to make reasonable adjustments is something which is rather more likely to come up in the context of housing. A failure to comply with the duty is something which constitutes discrimination. The duty applies to the tenant or to somebody who is entitled to occupy, but the important thing about reasonable adjustments in the housing context is that the landlord must receive a request from the tenant or a person entitled to occupy the premises, or somebody acting on their behalf. And only when that request is received does the duty arise. So what is the duty? Well, really important to bear in mind in housing that the duty to make reasonable adjustments does not cover physical features. So it doesn't apply in cases where, for example, a person wants adaptations to their home, where they want any sort of physical changes to the fabric of the property itself. Now, that's not to say that the Equality Act doesn't provide any protection in respect of those issues. It does. It has a lot of procedures to do with applying for permission for adjustments to be made to the property, or adaptations to be made to the property, and circumstances in which the landlord can be forced to give his or her consent to those adaptations. But it doesn't give rise to a claim in damages, and it isn't something which falls under the reasonable adjustments duty. So the one that we're mainly going to be looking at is whether a provision, criteria or practice puts the disabled person at a substantial disadvantage in relation to a relevant matter. So A provision, criteria or practice. Well, this is a wide test. We're looking at lots of different things which might be construed as a PCP. It might include one-off decisions, or it might include policies. It might include things like a rent criteria, so the requirement that you pay your rent. It might be a term of the tenancy relating to nuisance behaviour, so a requirement that you behave in a certain way or that you don't behave in a certain way. It might be a policy as to how rent is paid, on what day, or whether it should be by bank transfer, that sort of thing. Or it might be a practice as to the circumstances in which a landlord will seek possession. Or it might be a term, for example, that prohibits the keeping of pets, or that prevents a tenant from decorating. And that might be something which is significant if, for example, you have a visual impairment. What we can't do, and this Newcastle and Bagley says this, is you can't simply list things that you don't like and describe those as failures to make reasonable adjustments. Failure to make reasonable adjustments is quite a technical, sort of claim, and there's a lot of steps that you have to go through in order to make good your claim. And these cases do have to be pleaded very carefully to ensure that everything is there in order to join the dots and put the claim together. The disabled person must be at a substantial disadvantage. Well, substantial just means more than minor or trivial, so it doesn't need to be anything particularly significant, but it does need to be in relation to the enjoyment of the premises or the use of a benefit or facility entitlement to which arises as a result of the letting. That's not to say that it is terribly narrow. And there often will be a sort of slightly indirect impact on the enjoyment of the premises. So, for example, you might be at a disadvantage in relation to, you might be disadvantaged by a behaviour criteria, and the fact that you can't comply with the behaviour criteria might mean that you are then at risk of possession proceedings and ultimately at risk of being evicted. The duty is one to take such steps as it is reasonable to take to avoid the disadvantage. It is an objective test. And so, for example, if we're looking at, let's say there's a practice in relation to requiring tenants to clear the space before repairs will be carried out. And that practice might put the tenant at a disadvantage because in relation to the enjoyment of the premises, because of a mobility impairment, they are unable to clear the space, and as a result, repairs are delayed in being carried out. In those circumstances, well, what might be a reasonable adjustment to avoid that disadvantage? It might be that the tenant needs to be decanted. It might be that the tradespeople need to work around the tenant, or it might be that the landlord needs to arrange for somebody else to come and clear the space before repairs can be carried out. So there's lots of different things that might be suggested. And the question for the court will be, well, would any of those things have been reasonable? Would any of those things help? And one of the things that we're looking at then is the extent to which a proposed adjustment would be effective in reducing the disadvantage. So, for example, if a tenant it finds it difficult to meet the rent criteria because, for example, they are suffering from clinical depression, well, we might suggest that a reasonable adjustment to the rent collection policy or practice would be to send text message reminders to the tenant. Perhaps we might think that that would be something that would help. And the landlord might say, well, that wouldn't help, but she still wouldn't pay the rent. So in those cases, the question is, would that adjustment give the tenant a chance of being able to comply? Would there be a real prospect of her being able to avoid the disadvantage? And that's not a high test. So anything that gives somebody a chance might be something which would be a reasonable adjustment, so that if a landlord doesn't do it, that could be something which amounts to discrimination. I'm going to zip through that. Harassment. Interestingly enough, harassment in the context of premises does not cover harassment on grounds of sexual orientation. I'm not really sure why, but it doesn't, or religion for that matter. But note the word in section 26, harassment is where there is unwanted conduct related to a relevant protected characteristic. So it's not because of, and what that means is that the person who is subjected to the harassment does not themselves need to have that particular protected characteristic. If, for example, a white woman is treated badly because of her mixed race children, that is something which might engage section 26. Now, normally I would say that it also covers, for example, homophobic bullying against somebody who may or may not be gay or may not be straight. But that doesn't apply in the premises context. Sexual harassment is also covered by section 26. Now, historically, this wasn't a huge issue in housing cases, but I've certainly come across it more in recent years. And I know that there have been a number of sort of exposés as to sexual harassment, particularly in private tenancies. And I would expect that that was a symptom of this very short supply of affordable housing. Victimisation essentially is where a person is subject to a detriment because that person has done a protected act, and a protected act is essentially some either making or supporting a complaint under the Equality Act, but it's a broad test, so we're only looking at whether or not the act is in connection with or under the act. Bringing damages claims under the Equality Act. Well, first of all, there is no specific pre-action protocol. There did used to be, and you will see reference to there being a pre-action protocol. It used to require that the Commission was notified of the proposed claim. That went some years ago with little or no fanfare, and so now we're only looking at the pre-action conduct protocol. Now, in some cases, of course, where we're actually alleging a personal injury, for example, aggravation of a mental health condition, in those cases, the personal injury pre-action protocol will apply. A claim must be brought within 6 months. This is sometimes referred to as 6 months less a day. And that's because, unlike under the civil procedure rules, the time limit under section 118, in keeping with the previous rules which applied in the employment tribunal, time runs from the date of the discrimination, and that date is included. So it is safer to think of it as 6 months less a day. Conduct extending over a period of time is treated as done at the end of that period. Assessors. This may be something which we're a little more familiar with now, I hope. But essentially, the county court must appoint an assessor unless there are good reasons for not doing so. And in general, it's difficult to think of what would be good reasons. So I've referred there to the code. Well, that code is in fact in relation to claims under the services and public functions rules. So it doesn't directly apply, but it's of some relevance, I would suggest. And that code says that it would not be a good reason that the court believes itself capable of hearing the issue in the case without an assessor. And you'll hear lots of judges that say, well, what would an assessor add? Well, that's not really the point. The point of having an assessor is that it's a sort of jury function. The burden of proof, this is rarely an issue in housing cases, I would say, and that's because the case law is quite clear that when we're looking at reasonable adjustments and indirect discrimination, the burden of proof is of very little assistance. Where it is absolutely essential is when we're looking at direct discrimination or victimisation. So when we've got that because of test, then the burden of proof is absolutely essential. And of course, that's for obvious reasons, because nobody ever, or at least only very rarely, openly admits that the reason why they are sacking somebody or seeking possession against somebody or treating someone badly in another way is because of their race or because of their disability. No, they will say something else. They will say, it's because you don't fit in, it's because you're different from us, or he wouldn't have understood anyway, he wouldn't have wanted to have come to that party, he wouldn't wanted to have participated in that consultation. And in those circumstances where probably the person won't even admit to themselves that they are discriminating, that reverse burden of proof is really essential. But it's not just a reverse burden. So the guidance is called the Barton guidance, and that was approved in a case called Eigen and Wong. And if we look at sort of paragraph 5 of the guidance, the word could. So we're at the first stage of looking at whether or not the burden has reversed. We're only looking at whether or not a court could find that there was discrimination. And if a court finds that it could possibly be discrimination, then the burden goes on the other side, and at that point, the court or tribunal would normally expect cogent evidence to argue to the contrary. So in those cases, it's extremely important. In terms of remedies, the county court has the power to grant any remedy which it may grant in proceedings in tort or a claim for judicial review. Now, in most cases, of course, what we're probably just looking at is awards for injury to feelings, and we'll come on to that in a moment. But it's important to remember that it's not only that. One can also claim all the normal losses that one could claim in a claim in tort. So any actual losses, did it cause you to have to move house and therefore have to pay a new tenancy deposit? Did it cost moving fees? Did it cost private medical treatment? There are all sorts of actual costs that may have been incurred as a result of discrimination, and that might include personal injury. Of course, also available is injunctive relief. One might get an injunction to prevent a discriminatory decision from being made. And it also includes, because we're also looking at what can be awarded on a claim in judicial review, we're also looking at quashing orders, mandatory orders, declaratory relief. Quashing orders might be something which is very important. For example, in a notice to quit case, we might need to quash the notice to quit. But as I say, most cases, what we're going to be looking at is compensation for injury to feelings. So injury to feelings, the Vento case is probably something that you have all heard of. It provides for 3 bands of damages for injury to feelings. And what's been held is that what band a case is in is a matter of law, and that's something which a party can appeal if it is if it's a decision that they are unhappy with. Once we've identified which band a case is in, we're then looking at, well, where in that band is the case placed? And in terms of where in the band a case should be, we're looking at lots of different things, but it's a compensatory award and it is evidence-based. So we are not only looking at the severity of the discrimination, although that is something which is important. We're looking at the severity of the discrimination. Was there humiliation? Was there embarrassment? Was there physical discomfort? How long did it go on for? Was there a failure to make reasonable adjustments over a period of weeks or months? But we're also looking at the actual impact on the person. So it's sort of thin skull rule approach. If a person suffered aggravated depression over a period of many months, that is something which should be reflected in terms of where the award of damages should be pitched. And we can also claim damages for aggravated damages. It might seem that might be slightly counterintuitive, but there are lots of cases where aggravated damages are awarded, including the case of Vento itself. Now, I've put a couple of examples of injury to feelings awards. They're not, these are not authoritative at all, but I wanted to give an example of how one goes about assessing how much a case is worth. And so it's very, very similar to the approach that we take in personal injury cases. So first of all, we're looking at which band it is in and might broadly identify where in the band. So is it the top of the middle band, for example, or the bottom of the top band? And then we're looking at the individual facts, and we're trying to find cases which are similar. So to find those cases which are similar, or that we can at least draw some similar aspects from, we look at places like Harvey on industrial relations, which has quantum reports, or Lawtel, which also has quantum reports. And we pitch these together and we calculate them according to the RPI. And then that's going to give us an idea of the sort of amount of money that we should be looking at. So there's examples here, for example, of situations of relatively minor one-off acts of discrimination, but where there was an ongoing and more significant effect. And this on this slide, I've got some examples of some slightly more serious cases. So failure to make reasonable adjustments over 8 months, failure to make reasonable adjustments over 12 months, a dismissal, a discriminatory dismissal. And bear in mind, this is just the award for injury to feelings. Of course, there would also be loss of earnings in relation to a dismissal, and the offer of employment being withdrawn. So those are some examples, and hopefully that gives you an idea of the sort of money that we might be talking about in an Equality Act claim. Now, I have talked way over my allowance, so I'm going to pass you over now to Zia, who's going to talk about how this relates to homeless applicants.
Right. Thank you very much, Sarah, and hopefully everyone can hear me. Sorry, could I have the next slide? Thank you. So when you're thinking about the homeless applicant, there are 4 heads under which I'd like to consider whether damages can be claimed. Firstly, can damages be claimed for a breach of the Housing Act 1996 itself? So you've got judicial review proceedings alleging breach of a statutory duty. Does breach of that statutory duty itself give rise to a damages claim? Secondly, and of course you can see that there may be a degree of overlap here, can the homeless applicant claim damages in negligence? i.e., can the homeless applicant say, I am owed a duty of care in the way that you deal with my application, and you have breached that duty of care, and you have caused me loss which was foreseeable or should reasonably have been foreseeable? Can that ever apply in a homelessness case? Thirdly, damages for breach of convention rights. Can a homeless applicant say, because of the way that you have dealt with my application, because perhaps of the delay that has happened, perhaps because of the unsuitable accommodation that's been provided, can a homeless applicant say, well, that has actually breached my right to respect for my private life, my family life, or perhaps it's amounted to inhuman and degrading treatment, for which I am entitled to claim damages under the Human Rights Act. And finally, can a homeless applicant say, the way that I've been treated, the way that my homeless application has been processed, has meant that I've been discriminated against for the purposes of the Equality Act, and therefore I have a right to claim damages for injury to feelings, as Sarah was explaining, under the Act itself. So those are the 4 headings, and I'll go through it pretty quickly. So in terms of damages for breach of the Housing Act, I mean, I could just deal with this by a one-word answer, which is no. O'Rourke and Camden makes clear, it's a House of Lords case, and it's been cited repeatedly since, that there's no breach, there's no right to damages for a breach of statutory duty. In that case, in Mr. O'Rourke's case, he was seeking damages for breach of statutory duty not to provide him interim accommodation. He had been provided with some, he'd been unlawfully evicted from it, and I think he'd slept in a park for a day or so before he got accommodation restored. And he said, well, that gives me a right to claim damages. And the House of Lords said, no, there's no private right of damages. So could I have the next slide, please? Thank you. And that sort of analysis really carries on when one is thinking about Part 6 of the Housing Act as well. And the court had, the case of X and Hounslow is a very, in one sense, is a factually horrific case, because you had some very vulnerable tenants with learning difficulties who were being exploited by local youths over an extended period of time. And they themselves were known to the social worker. And it ended up with them being effectively kept hostage in their own home and being made to eat their own feces and to drink urine. And I mean, the facts were really, really extreme. And they brought a claim for damages, saying that there was a common law of duty of care in those circumstances to rehouse them. And that was successful in the High Court. The judge found that it was reasonably foreseeable that they would be attacked if they wouldn't be moved. But the Court of Appeal allowed the appeal of the local authority and said that there'd be no assumption of responsibility for the claimant's safety to move them to temporary emergency accommodation. And simply the carrying out of functions under Part 6 wasn't sufficient to impose a duty of care. Now, another reason why it said that there's no duty of care when you're looking at no direct damage for breach is because there are alternative remedies available. And that was said fairly recently in the case of Derby and Richmond on Thames, another very sad case where there was a cancer sufferer who moved to live with his sister and her children, and he was seeking accommodation, saying that he was at risk of infection from his sister and her child, and he wasn't provided with any accommodation. He did eventually die, but it was held that there were no damages available for the fact that he hadn't been provided with accommodation under the Housing Act. And the court also said that there was no duty of care in the function of exercise of social housing. So that is giving us a clue, perhaps, as to the difficulties that any negligence claim might face as well. And so I wonder if I could have the next slide. And really, the law of negligence has seen a lot of activity in the courts at the highest level. And the most recent very significant case was Gian and Poole Borough Council, which effectively considered whether you could have a claim in negligence because of an alleged breach of duty under the Children Act. So Gian and Poole was factually is an interesting case because it involved a family being housed in accommodation adjacent to neighbours who were known to have engaged in antisocial behaviour. And those neighbours then mounted a campaign of harassment against the family, and the family had to put up with this for about 5 years until they were rehoused. And what was said in that case was, well, because the local authority has a duty to children, discretion, a power to deal with children in need under Section 17 of the Children Act, and also has safeguarding duties under Section 47 of the Children Act, their failure to do anything in that case, their failure to rehouse the children, even to the extent of taking them away from the care of their parents, that failure meant that they'd breached a duty of care to the children. Now, the Supreme Court, on the facts of the case, found that there had been no such breach in that case, and also, echoing Sarah's point, commented on how these cases need to be very carefully pleaded. But the headline is that they said that public authorities can come under a duty, common law duty to protect from harm in circumstances where the principles applicable to private individuals would impose such a duty. So it said there's no special category that a public authority would fit in. But the examples they gave were, for example, where the authorities created the source of danger or has assumed a responsibility to protect the claimant from harm, unless this would be inconsistent with the legislation. It's my view that in terms of assumption of responsibility by accepting a homeless application, I cannot see that, given O'Rourke and Camden and the authorities subsequently, and the approving citing of O'Rourke and Camden, that simply by running a homelessness scheme, an authority can be said to have assumed responsibility. I think that it's not straightforward, and I suspect not everyone will agree who is asked, but it may be possible, perhaps, to argue that where in the operation of the Part 7 scheme, a housing authority creates a source of danger, which is then realised, that there might be an argument that they breached their duty of care to that person. So, for example, there'll be no reported cases on this, but for example, where a victim of domestic abuse applies for homelessness assistance and is accommodated next door to the person she is saying has abused her, and then suffers injury as a result of that, I wonder whether in that very extreme and frankly pretty unlikely example, it might be argued that there had been a breach of duty of care. But I think in almost the overwhelming majority of cases, it's my opinion that there isn't going to be a valid claim in negligence against a housing authority for how it has dealt with a homeless applicant. So I wonder if we could go to the next slide. Then that takes us to convention rights. And in a way, the way that I'm doing, so breach of Housing Act damages never, negligence almost never, and perhaps never, depending on whether the creation of source of danger principle can be extended or not. Breach of convention rights, the case law, it says that it's possible, but it's difficult. So you can get damages for breach of convention rights where it's necessary to afford just satisfaction, i.e. without damages, there won't be justice. And what the Court of Appeal said in a case, well-known case of Anufrijeva, was that damages are not an automatic entitlement, but they are a remedy of last resort. Anufrijeva, as we will see, is a key case. It's a key case which is frequently used for the courts to find that there is no right to damages for breach of convention rights in any particular case. The other thing to bear in mind is that exemplary damages may not be claimed because, as under the Equality Act, damages under the Human Rights Act are compensatory. So exemplary damages are prohibited. Of course, that doesn't mean that aggravated damages couldn't be claimed in an appropriate case. I'm just going to, thank you. And in terms of the rights we're talking about, we've got Article 3, Article 8, and as we all know, Article 8 may impose positive obligations which are inherent in an effective respect for family life. Sorry, I wonder if I could have the next slide. So this was the start of the jurisprudence on breach of convention rights. And at this stage, this was a very optimistic decision. What's interesting about Bernard is that every case after this has said Bernard was right, and then explained why, even though Bernard was right, damages can't be awarded in the particular case under consideration. But if we look at the facts of Bernard, they were actually no less serious than many cases subsequently, in my view, where damages haven't been awarded. Just very briefly, the claimants had 6 children. The wife was severely disabled and relied on a wheelchair. She was doubly incontinent. She suffered from diabetes, and her husband was her primary carer. The family applied as homeless under Part 7, and they were found to be intentionally homeless. And that decision, although I think it went up to the Court of Appeal, was upheld. They also argued that the authority was liable to provide them with accommodation under the National Assistance Act, which would now be the Care Act. And the local authority, this is important, the local authority accepted that they were obligated to provide accommodation under Section 21 of the National Assistance Act 1948. Now, that didn't happen for quite some time, and so the Mr. and Mrs. Bernard, they brought a claim for damages. And what the court found was that there'd been a 20 months unlawful delay in providing suitable adapted accommodation, during which time the claimant was living in deplorable conditions. And they gave 8,000 to Mr. Bernard, who was the carer, and 2,000 for Mrs. Bernard. But if one looks at the judgment, it's right to say that the local authority must have really annoyed the court, because one of the reasons that the judge gave for awarding damages was that after the hearing itself, the authority had failed to comply with either the original or extended timescales with the court order. And they'd also at one point threatened to evict the claimants. So it was, in one sense, a case where the judge was completely fed up with the authority. Sorry, if I may move on to the next slide. So Anufrijeva, a year later, upheld Bernard and said it was correct. But so it was hard to think of a case where you would get Article 8 damages, where you wouldn't, the conditions weren't so serious that they engaged Article 3. Of course, Bernard was one of those cases, because in Bernard, the court found that Article 3 wasn't made out. The Court of Appeal said Article 8 may be more readily be engaged where a family unit is involved, and where the welfare of children was at stake, then Article 8 might require the provision of welfare support, so to allow family life to continue. But at the very least, there had to be knowledge on the part of the authority that private and family life were at risk. And I'm conscious of the time, so I'm not going to read all of this. But what the court is saying is there's got to be a glaring deficiency in the behaviour of the public authority. And the court also, the finding of breach of Article 8 would be rare and would only be likely to occur where it impacted severely on family life. So I'm going to whiz through these a little bit now. So recently, there was the case of McDonough and Enfield, where the court found that there was no breach. And it is the facts arguably are more serious than those in Bernard, but nonetheless, no breach was found, even though the court found that the local authority should have acknowledged the homeless application in March of 2015, should have provided interim accommodation, was under a duty to provide interim accommodation from December 2015, and no accommodation was actually secured until February of 2018, shortly after judicial review proceedings were issued. But the judge said there was no breach of Article 8 because the authority were making efforts to find suitable accommodation from January 2016. I mean, it's a very sympathetic case to the authority. So I wonder if I may have the next slide. The only thing I would point out on McDonough is this is a second bullet point. The judge noted that there had been no separate claim by the claimant's disabled child who was not able to use the upstairs bathroom, had a commode in his downstairs room. The claimant, because it was just her claim, her additional caring responsibilities because of the failure to provide suitable accommodation didn't amount to an Article 8 breach. So that's something to bear in mind, that in a case such as this, even where let's say where there is a disabled child who is very adversely affected by the failure to provide suitable accommodation, then even though they may not be the homeless applicant, they could still be considered as a claimant in a convention human rights claim. Sarah, I wonder if we may have the next. Okay. So Sarah's talked to you, section 2021. If I may just go to the next slide, please. So Sarah's mentioned section 20 and 21. I won't go through that again with an eye on the time. But section 29 is important. A service provider must not, in providing a service, in exercise of a public function, discriminate against that person by subjecting her to any detriment. And a duty to make reasonable adjustments applies to a service provider or a person who exercises a public function. Now, I don't know what Sarah thinks, but my view is that that section 29 reasonable adjustment duty doesn't actually require a request to be made, as opposed to the, Sarah is nodding, I can see. So that's very helpful when we're talking about homeless applications, because there is no need to request a reasonable adjustment. Sarah has dealt with section 114 and 18, and so we have the next slide, please. And then the Vento guidelines, so we'll move on to the next slide. So I just wanted to give you a case study, because there are no reported cases, as far as I'm aware, of Equality Act damages being awarded by the court in a homelessness case. So I thought I would give you a case study from one of my own cases. So this was a homeless applicant who had serious mental and physical health problems. He was diagnosed with schizophrenia, depression, diabetes, high blood pressure, and heart and kidney problems. She'd had 2 heart attacks. Her husband had diabetes, high blood pressure, and mobility issues. They had 2 adult children, and they were fleeing their home because of violence. They made a homeless application at 11 in the morning, and they were kept waiting in the office all day. No interim accommodation was offered or provided. And at 8 o'clock in the evening, they got a decision letter saying that you're not homeless because the accommodation you're fleeing from is reasonable for your continued occupation. They slept in a car that night, and interim accommodation pending a review was refused, and judicial review proceedings were issued. The court ordered the authority to provide accommodation. That led to the local authority providing 3rd floor accommodation, which the homeless applicant had real problems getting to. She had a respiratory attack going up the stairs. Now, following complaint from her solicitor the next day, alternative hotel accommodation was offered, but when they arrived, they were told the authority had not booked it, and so it wasn't available. That led to another night in the car. And the next day, the claimant was admitted to hospital with chest problems, and she was diagnosed with chest infection and an asthma attack. And 3 days later, other accommodation was offered, which was suitable. So it was argued in proceedings brought in the county court, separate proceedings, that the authority had unlawfully discriminated against the claimant by failing to make any adjustments to its procedures and practice to take account of her disability. Firstly, in the way that it dealt with her application, including making a same-day decision after, out of hours, which had a much greater impact, we said, on a disabled person with her disability than the ordinary robust person. And then providing interim accommodation without ensuring it was suitable, taking into account the applicant's disability. And what we said was that there didn't appear to be any system at the point that interim accommodation was provided to ensure that it was suitable to take any protected characteristic into account. Now, damages were sought for breach of under section 119, but also aggravated damages were sought as well, injury to feelings and aggravated damages. And the local authority compromised for £12,500. And the offer that was made was 10,000 straight damages and 2,500 aggravated damages. And so if we may go on then to the last slide. I apologise for having rushed through this, but I'm just very conscious of our time limits. So when you've got a homeless applicant and you think that the Equality Act is engaged and may have been breached, what are the sort of things that we should be thinking about? Well, a really important point, I think, is does your local authority always tell homeless applicants to attend the housing office on the date of eviction? that really impacts on disabled people, particularly where they need adapted accommodation, because it's almost going to be, well, I cannot see how a local authority is going to be able to provide suitable adapted accommodation at that point. And therefore the person may be accommodated in unsuitable accommodation for a short period before suitable accommodation is found. But if that's their procedure for everybody, what provision have they made to their procedure to take account of the fact that a person is disabled? Are they telling everyone just to attend on the date of eviction? That's unlawful, in my view. And also, what's the practice for securing interim accommodation? Now, I know what Sarah said about the burden of proof not being that important, apart from in cases of direct discrimination. But in my opinion, in cases like this, the burden of proof might be very interesting indeed, because if you can prima facie establish a case that you've been given unsuitable accommodation because the local authority failed to make a reasonable adjustment to its procedure so that you weren't required to attend on the date of eviction, and they would have to show, in my view, well, actually, we haven't discriminated because of X, Y, and Z, and this is why we follow the policy that we do. And that might lead to some very interesting documents either being disclosed or an admission that no such documents or policies exist. Right, thank you very much. I think that's the last slide. And we are almost at the end of time.
Fantastic. Well, I understand we've got some questions which have come through, which I'm going to put to our panel members in the dying moments of the session. So first of all, for Sarah, the first question that we have that's come in is that a reasonable adjustment has to be made by, request for a reasonable adjustment has to be made by a tenant. Does he or she have to make clear that the request is pursuant to section 20 for that request to be effective?
No, is the answer. But it does refer to them needing to be clear about the substantial disadvantage. I would say there's no requirement that it be in writing. There's no formal requirements at all. It doesn't need to be made actually by the tenant. It can be made by someone acting on behalf of an occupier even. But it is safer, isn't it, to put something in writing, and it is safer to refer expressly to the duty to make reasonable adjustments. As a matter of case law, when we're not looking at requests, there is no requirement at all to even identify what you're asking for, what the reasonable adjustments should be. All you have to do is to identify the substantial disadvantage and to ask them to make reasonable adjustments. It's for them to decide what those adjustments are. That said, by the time you get further on to the point of actually issuing a claim, you do need to be clear about what adjustments needed to have been made, because otherwise you put the court in an impossible situation, really. The court needs to be able to assess whether what is proposed is or is not reasonable.
Brilliant, thank you so much for that. So the second question, we're just going to go through all the questions that were there during Sarah's talk first, and then we'll turn to Sarah. So the second question for you, Sarah, was, do we no longer have to report our Equality Act cases to the Commission?
No, you don't.
Very good.
It was always a slightly strange requirement, and I was never really sure what the consequences of not doing so were supposed to be. And in cases where I did report it to the Commission never knew what to do with those reports. But yeah, it's gone. Like, no one seemed to have noticed that it's gone, but it has.
Brilliant. And final question for you. If you were considering whether the duty to make reasonable adjustments has been breached, what level of evidence would you expect to be required to determine, first of all, whether a disability causes substantial disadvantage under Section 6 of the EA 2010, and secondly, whether the steps requested are reasonable and required? And we've got an example here. So when a landlord refuses to adjust a tenancy agreement that prohibits dogs for a tenant who says they require a support dog, is the example given.
So this takes a bit of answering, and it's perhaps best to start with what findings the court is going to need to make. So there is a case called Rowan and the Environment Agency, which looks at what findings a court or tribunal is going to need to make in a reasonable adjustments case. And that tells you what needs to be in the pleadings. So you need to be able to plead the nature and scope of the disability, the nature and scope of the effect on day-to-day activities, and you need to be able to plead exactly what is the substantial disadvantage. And so because you have got to plead those facts, likewise we need evidence in which on which to base those pleadings. So in terms of the substantial disadvantage in relation to a PCP, that is something which you will probably need expert evidence of. Not necessarily, there will be cases where it is abundantly clear. So, for example, do stairs put a wheelchair user at a substantial disadvantage? Well, you don't need expert evidence of that. So often it's going to be very clear, but in other cases, you definitely will need expert evidence. In terms of whether a step is reasonable, that is a factual determination for the court or tribunal to make itself. There are some aspects to that on which you would want expert evidence. So, for example, if effectiveness is an issue, then that is something on which you would want expert evidence. Somebody to comment on, would the proposed adjustment, would the proposed step give that person a chance of not being at that disadvantage? And as I say, that's an expert evidence point. Other issues in terms of reasonableness, of course, are just purely factual. For example, the cost of the adjustment, whether it's practicable. Those are all things for a defendant to a discrimination claim to adduce evidence of. And finally, it was whether or not the reasonable step is required. Well, of course, that's not part of the test. If you what you need to identify as a claimant is the substantial disadvantage, and by operation of law, in that circumstance, a reasonable step is required. Whether it is reasonable is then a separate question, but it isn't for a claimant to demonstrate that a step is required, that it is necessary. That's putting the bar too high. In relation to dogs, well, this is more complicated than you might think. So there was a case before the Equality Act under the DDA called, I think it was called Thomas Dunn. I might be slightly misremembering that. And that was a case where a person had a dog which they said was beneficial for their mental health. And they had a letter from a GP to say that this dog was beneficial to this person's mental health. And that case did not succeed because although there might be said to be a disadvantage, it didn't go to the use and enjoyment of the property. But I would suggest that case could be approached differently. So first of all, under the DDA, you couldn't argue indirect discrimination in premises cases. So now you can, and that gets away from the necessity of attaching to the use or enjoyment of the property. So you could bring it instead as an indirect discrimination case. But it's also fair to say that that case wasn't brilliantly evidenced or possibly brilliantly argued, because there are ways of, I think, of bringing those facts within something that would better amount to a claim. But it is fair to say, I think, that a dog being beneficial to your mental health is not good enough. It's not going to establish a claim. Yeah, I think what needs to be happening really is that actually, because you need the dog, therefore you are disadvantaged in relation to the term of the tenancy, because then you are exposed to possession proceedings and likely to be evicted. So it needs to be sort of put in on that basis.
Great. Well, thank you very much for that, Sarah. Zia, you also have 3 questions. The audience have been very equitable in that regard. So the first question for you is, in the case of EU national homeless applicants who are wrongly denied assistance as ineligible, can they claim that there is discrimination on nationality grounds contrary to EU law, and therefore claim damages for breach of EU law? And then it finishes with a smiley face.
Well, and I'd like to thank Simon Cox of Dietetic Chambers for that question. And I think I probably can't answer it in the very short time that we have, Simon. Perhaps we can chat about it later. I don't really think I can deal with that question on the hoof. So I think I'd rather pass on that and move to the next one.
Absolutely. Okay, well, the next question is, how would this work if a council has accepted responsibility to rehouse a family with disabled children, that they accept the current home is unsuitable for their needs, but due to delays in doing so, a person suffers injuries because of it?
Well, I don't know whether that question is being asked in respect of negligence or just breach of not following the statute. In terms of negligence, I think it'd be very difficult to bring any claim because it's an omission. It would be an omissions case. You failed to do this, and for that, that I can't see how a claim in damages would be successful. So I think that's a short answer to that. I mean, it's a very, there are lots of, I'm assuming that the responsibility has been accepted under the Housing Act, that the delay is happening because the authority hasn't got any accommodation. So we're sort of coming almost perhaps in a McDonough type scenario where the court found that there was no breach of Article 8, but also I think that a claim in negligence would not succeed. And the best thing to do would be to try to start a judicial review to force the local authority to provide suitable accommodation in accordance with their duty.
Great, thanks, Zia. Just one more. Would or could it be negligence for a breach of duty of care if a local authority did not acknowledge a family who were homeless, even if they knew they were homeless?
I think the answer to that is no. That's because negligence is, you don't get damages in any event for pure economic loss in this sort of case. And so where a local authority doesn't acknowledge that a family are homeless, they could be in breach of their duties under Part 7, but the remedy for that would be judicial review or complaining to the Ombudsman.
Fantastic. Well, that brings us to the end of our questions. So thank you for everybody who's attended, who I'm sure if we were in person would be clapping now for Sarah and Zia for their very useful contributions today. Do remember that the slides, if you want to check any of those case references, dig into this a bit more, will be available online, as will a recording of the session if there's anyone else you think might be interested in seeing any of this. Now, I've got some more questions that just popped up in my inbox literally as I was wrapping up there. I'm going to defer to the panelists as to whether they're interested or able to take further questions given the time. What's the thinking on that, Sarah and Zia?
Well, we'll have a go at answering them. Can you?
Absolutely. So I think we've got a clarifying question in relation to the last question that you just dealt with, Zia. So for clarity, if a local authority were made aware a family were homeless through, say, assessments, say Section 17 assessments, but did not even acknowledge this, what would the position be?
Yeah, I think the position is as I've said, which is that you would go by judicial review or a complaint to the local authority ombudsman. But it wouldn't be a damages claim under negligence or for breach of convention rights.
Great, thank you. And then a final question, perhaps unless another one pings in. Can a local authority decision to deny an applicant the right to bid for accommodation under its allocation scheme be challenged under the public sector equality duty if the applicant has moved outside of borough due to a serious medical condition to avoid the risk of infection from COVID-19 and previously shared accommodation that was inside the borough? We've got a pandemic relevant question.
I mean, that doesn't sound like a question about a damages claim. I think, Alex, that's probably a question to talk about later by email. But obviously there's no residence requirement in terms of the PSCD. But I think that's probably something to explore on another occasion. I mean, what I would say is that the duty to make reasonable adjustments applies to allocations as much as it applies to other things. And so there may be a way of bringing these sorts of issues when we're talking about rehousing people, whether it happens quickly or slowly. There may be ways in particular cases of bringing that as a discrimination claim, but it is difficult and it's certainly complicated.
Great. Well, you can always follow up by contacting Sarah if you'd like to delve into that anymore. Well, I think that brings us to the end of the webinar. So thank you again to Sarah and Zia, and for all of those who attended. I hope you can enjoy the rest of the somewhat sunny afternoon. Thanks.